Get ready, guys, for dictation at the speed of 120 words per minute. Start. While appreciating the respective contentions of the learned counsel for the parties and on perusing the decision relied upon by the learned counsel for the appellant as well as the decision reported in the case bracketed supra, we feel that a detailed analysis is required to be made in order to find out whether the issue calls for further deliberations so as to arrive at an authoritative pronouncement. Stop. One common feature which we noted in all these cases is that all the above decisions were rendered by a division bench consisting of two judges alone. Stop. Para. Though in the decisions in which the principle laid down has been either followed or similar view has been taken, we find a common thread in all those decisions in having laid down as a proposition of law that suppression of material information which a candidate was called upon to furnish and which he failed to do, such concealment would result in serious consequences and also not befitting the nature of service for which the recruitment was made. The state would be well within its powers to resort to cancellation of such appointment when the appointee was undergoing probation in order to ensure cleanliness in the service. Stop. We feel it appropriate to make a brief reference to the principles laid down in the various decisions, pros and cons, in order to pass appreciate orders in this appeal. Stop. Para. It is seen that verification of the character and antecedents in one of the important criteria to test whether the selected candidate is suitable to a post under the state. Stop. Though he was found physically fit, passed the written test and interview, and was provisionally selected on account of his antecedent record, the appointing authority found it not desirable to appoint a person of such record as a constable to a disciplined force. Stop. The view taken by the appointing authority in the background of the case cannot be said to be unwarranted. Stop. The tribunal, therefore, was wholly unjustified in giving the directions for reconsideration of his case. Stop. Para. Though he was charged or acquitted of the criminal offences, the same has nothing to do with the question. Stop. What would be relevant is the conduct or character of the candidate to be appointed to a service and not the actual result thereof. Stop. If the actual result happened to be in a particular way, the law will take care of the consequences. Stop. The consideration relevant to the case is of the antecedents of the candidate. Stop. Appointing authority therefore was rightly focused this aspect and found it not desirable to appoint him to the service. Stop. If once such fraud is detected, the appointment orders themselves, which were found to be tainted and vitiated by fraud and acts of cheating on the part of employees, were liable to be recalled and were at least voidable at the option of the employer concerned. Stop. Para. This is precisely what has happened in the present case. Stop. Once the fraud of the respondents in getting such employment was detected, the respondents were proceeded against in departmental inquiries and were called upon to have their say and thereafter have been removed from service. Stop. Such orders of removal would amount to recalling of fraudulently obtained erroneous appointment orders which were avoided by the employer appellant after following the due procedure of law and complying with the principles of natural justice. Stop. The aggrieved are all those who had similar or even better qualifications then the appointee or appointees but who had not applied for the post because they did not possess the qualifications mentioned in the advertisement. Stop. Thank you guys. Now go for typing the same matter in 20 minutes.